Hi, everyone. Welcome back to the Business Immigration Benchmark. I'm your host, Laura Blaneres. Y'all, we've reached episode 10. My producer promised me that by episode 10, we would have ironed out all the kinks. And I think, dare I say, he's right. I now know how to troubleshoot all studio tech and lighting fixtures. All jokes aside, I think I've learned a lot about the creative process and that it's just that it's a creative process. So thanks for tuning in. I've been outside my comfort zone a lot with, making recorded predictions and having some big opinions and insights. But the process has been, dare I say, fun, and I'm learning a lot. So hopefully you're on this journey with us, learning a lot. For those of you that have reached out, thank you for providing the feedback. I encourage you all to reach out to me on LinkedIn with any questions, comments, thoughts on new episodes, or questions to include in our benchmarking surveys. All of our episodes are on Spotify and YouTube, so find us there. And again, thanks for listening. This episode is going to be all things onboarding challenges. I've heard from some of you listeners with your struggles for, wrangling, recruiting, making sure the onboarding process is smooth. For foreign national employees, it can be especially rough to onboard employees in the remote era, and even more so when you've got foreign national and visa sponsorship in the mix. So we're going to cover what works, what doesn't, how to manage the program effectively. So with that, let's dive in. So like I said, today we're talking all things onboarding foreign national employee candidates. I've heard some feedback from some listeners, so thank you. And like I said, this is an issue we wanted to cover in light of the feedback. So generally, what does the process look like? And I'll kind of walk through what ideally the process looks like for onboarding a foreign national candidate. Ideally, it would look like the foreign national candidate using the company's recruiting tool. So whether that's Greenhouse, I've heard a lot of my clients use, or some other tool for the applicant, where that candidate submits their resume, completes a series of questions that the company collects. Ideally, that set of questions includes some sort of question about, are you work authorized in the U.S.? And do you now or will you in the future require visa sponsorship? And ideally, the foreign national candidate is correctly and honestly answering those questions. Then ideally in the process, there is a protocol within the company that the recruiter or the talent acquisition team has a handoff either internally or externally to Immigration Counsel for further assessment. Because what we want to make sure with that assessment is that the foreign national candidate has a viable basis for that company to sponsor them. Unfortunately, the U.S. system does not have a sponsorship pathway for every foreign national candidate. If the foreign national candidate's already in the U.S., some companies assume, well, they have a way to be here, and they may, but that may expire very soon. And so the immigration assessment, what it's meant to do is make sure the company has a viable pathway to sponsor that foreign national candidate once they onboard, and that the company is comfortable with the cost, the timeline, and the resources that are required to sponsor a foreign national candidate. One thing I'll note here is ideally in this process, you're only doing the immigration assessment for top candidates. So we also want to preserve resources, whether it's the internal company team that's doing the immigration assessment, or there's a handoff from recruiting, talent acquisition to outside Immigration Counsel. You only want to be completing the immigration assessment for top highly considered foreign national candidates because you want to preserve the resources for the immigration assessment. You don't want to be sending hundreds of immigration assessments that aren't seriously considered candidates. So one thing to kind of keep there. So that's the ideal process. But, what are the challenges that I'm hearing from clients, from folks that I'm talking to? Well, the common challenges I see are that recruiting or that talent acquisition team doesn't hand off the candidates to the internal immigration team for immigration assessment, or the recruiters or the talent acquisition aren't handing off to outside immigration counsel for the immigration assessment. And that causes challenges when an offer has been made to the foreign national candidate and then accepted. The immigration team then that has to go through with the immigration support, whether that's proceeding with an immigration sponsorship that needs to be in place before that candidate onboards. It expedites the timeline, and that pipeline for the handoff is tougher because there's not been any insight into the expectations for onboarding for that candidate. So that's a big challenge, and that's probably the most common one that I've been hearing about. The other common challenge is that there's a lack of protocol. This happens usually with smaller companies that maybe haven't sponsored a foreign national before. And so this is often the HR professional for the company is tasked with figuring it all out. So the manager either knows of their previous colleague that requires sponsorship and they want to bring them on board. And the manager has had these conversations without, a more formalized recruiting process. And then HR is tasked with, getting them onboarded to the manager's timeline that hasn't been discussed. So the lack of protocol is another one that I find a lot with smaller clients that maybe haven't sponsored foreign nationals before or have only, sponsored foreign nationals on a one-off, or it's not a general process that the company is used to implementing. So that's a big hurdle because they're sort of figuring things out on the go. The other challenge that I've seen a lot recently is when foreign national candidates do not disclose their need for employer sponsorship. So as I was mentioning in the ideal process, the company has some sort of recruiting or application tool that asks the candidates, do you have work authorization in the US? And the follow-up question is, do you now or in the future require any kind of visa sponsorship? We've seen a pattern where foreign national students, especially the F1 students that maybe have the OPT EAD card that does not require any sponsorship for that initial onboard on the EAD because it is an open work permit, essentially. We've seen those F1 students say, yes, I'm work authorized in the US, and no, I don't require sponsorship. I think the most generous interpretation when they answer the question, no, I don't require sponsorship, is that they understand that their work permit is open, that EAD can work for any employer. But again, the most generous interpretation is maybe that foreign national is not aware that beyond the year of OPT work authorization, they'll require some involvement with their employer for STEM extension for the additional 2 years work permit post-graduation. And they definitely will require some sort of visa sponsorship for H-1B or whatever visa they may qualify for and need to qualify for in order to remain in the U.S. beyond their F1 postgraduate work authorization cycle. My clients have seen a number of F1 students not properly answer that question, and this jams up the future support. So this foreign national candidate accepts their offer. They have the F1 OPT EAD, they onboard, and often they're not discovered by HR or our contacts in global mobility within the company until the very last minute before we start the registrations for the H-1B cap lottery. So that becomes kind of a protocol problem in the sense that you almost have to prepare as an HR global mobility professional throughout the year to be screening your employee population, because occasionally these folks onboard without any notification to receive future immigration support, and they come out of the woodwork last minute when they find out their EAD is expiring. So the worst case scenario where I see this happen is, they present an EAD to onboard the team that supports their I-9 compliance, which again, the I-9 onboarding process team might not be the same team that is my day-to-day contact or is responsible for immigration. So that F1 who onboards with an OPT EAD, presents the EAD, completes the I-9, shows the expiration, like no problem. And then the I-9 system that the companies have will automatically remind the foreign national employee then that, hey, we need another documentation, your EAD is expiring. I've seen this happen, that an employee comes to HR saying like, okay, what's the plan? And that HR doesn't even know that they required support. And you go back through their employment record And they've said, no, I never required support. So it's a lot of confusion that requires support at the last minute. So those are the three key challenges. And, what have I seen that works? Which, what's the preventative medicine to alleviate these challenges from the get-go? I think it's best to have a foreign national candidate protocol. And developing one when you're just having one foreign national might seem like a lot, but it makes sense because it prevents these challenges in the future, like last minute sponsorship, because last minute sponsorship, quite frankly, is just more expensive. You have to pay the expedite fees. You may have to be paying your attorney more to get the paperwork filed faster. So even though you have maybe only sponsored one or two foreign nationals, getting the protocol in place will save you money. The other thing I want to mention here is regular check-ins and training with all stakeholders involved in the hiring process. So depending on the size and scope of your organization, depending on how your hiring process works, you might be involving a ton of people. You might be including a whole recruiting team. That recruiting team might be external consultants that support recruiting for you. It might be your entire HR team, whoever's interfacing with the candidate pool and doing those initial screenings, reviewing those applicants before they get to the manager, or even including the managers if managers are closely involved in the process. And you're training them on the internal protocol. And ideally, you're involving external immigration counsel here to give them high level, the ABCs of immigration sponsorship. And what the biggest takeaway you want to give the internal teams that are involved in the hiring process are those compliance questions that should be involved in the applicant screening, and also timelines and costs that are associated with employment sponsorship, so that everybody that's involved who may be responsible for budgets, who have vested interests in onboard timing, like the managers, have a really good sense of what it costs and how long it takes to onboard candidates in various statuses, so that they have reasonable and managed expectations when moving forward with hires. Because that's often the biggest tension in these onboarding processes for foreign nationals, that the manager wants the candidate to onboard in 2 weeks' time. And if you're pursuing an H-1B transfer, depending on what counsel you work with or what type of program you have, that may or may not even be possible. The other thing you want to be doing here is have clear conditions noted in the offer letters. So you want to make sure your offer letters have something about the start date conditioned upon ability to present valid work authorization. I think that's pretty standard, but occasionally I'll see offer letters that don't mention that. The reason you want to make sure that's really clear in your offer letters, if it's not already, is because if you have one of these foreign national candidates to employee who have not identified that they require immigration sponsorship, because again, most generous interpretation weren't aware that they require the sponsorship, that it's in all their documentation that they need valid work authorization to start, and that if they don't, their start date is conditioned upon that. So that means that their start date could be pushed back if there were any issues or delays in receiving the correct work authorization documents. The other thing you want to have in your offer letters, perhaps its addendum, is some sort of statement about green card sponsorship policies. This one, I don't see all of my clients, all of the companies I work with or talk to have, but I think it's a great idea. So that's why I'm recommending it. Even if it's just an add-on, maybe it's not in the verbiage of the letter, but it's something that's sort of included in the package they receive for their offer acceptance. I think it's important to have early on, because I've definitely seen, again, in situations where the recruiting or the talent acquisition or even the manager are not that strong with visa immigration sponsorship. Maybe they're new at it. Maybe they're a little naive in the process. They might make statements in the interview process that you as HR, as global mobility, don't know what they're saying. Or maybe they made promises in the interview that aren't in line with the company's green card policy. If you've got the policy stated in that offer letter, it would prompt that foreign national candidate to employee to ask questions, to inquire further. Oh, I heard this in the interview, or bring up any concerns that they have early on. So the earlier you can put this type of green card authorization policies in their hand, I think it's going to be for the better in that it'll just be the right disclosure for foreign nationals to look at, and that you want the information in their hands so that if they have any questions, if they need an exception, like maybe they're running out of time in their H-1B. So like I said, not all of my clients or all companies are adopting the green card policy disclosure in the offer letter or recruitment process, but we need to be identifying these issues early on in the process to ensure for the company and for the foreign national employee's sake that they have the maintenance of work authorization. So it's not just the onboarding of the visa, it's also the maintenance of work authorization status. And as many of us know that are knee deep in this field, in the trenches here, will know that the green card strategy also plays into it. And so managing the foreign nationals' expectations early on is important in the onboarding process too, because if they're dissatisfied with the green card sponsorship policy better that they know before onboarding, I've definitely seen employees leave companies because of long or their perceived too long of tenure requirements, or they didn't know and then when met with the green card policy are really upset. So we all know that it's best to manage people's expectations up front, set up the strategy. And with that, most folks then become comfortable with what the strategy is because they've had that conversation ahead of time. So that's a recommendation to consider, is adopting that disclosure of the green card policy within the recruitment process, especially if you know you're supporting a candidate who's a foreign national, making sure that policy is documented, because recruiters, especially at the beginning, are not necessarily fluent in immigration sponsorship. And so having some sort of takeaway documentation for them to give to the foreign national is a really helpful tool. So what I've seen that doesn't work is when recruiters only considers the manager's timeline in their discussions with the foreign national. So this is when there's not a protocol for foreign national candidates, or HR is not involved, or global mobility is not involved. That's when things get really sideways and managers get really upset because their talent, their employee can't onboard in the timeline that the recruiter set for them. So I think when you're creating protocols, when you're doing training, having all the stakeholders, everybody involved in the room for the discussion of what Immigration Counsel can do, committing to the timeline for Immigration Counsel to meet for H-1B transfers, for example, and then that in coordination with setting start dates. And then also having a protocol for if things are delayed in the immigration sponsorship, like if there is a RFE in the H-1B transfer process, how that may impact the H-1B start date. How will that be communicated? How will that handoff for the communication look like internally to set the right start dates? That's all to say that the best protocols and the most successful onboarding programs with foreign nationals have all the stakeholders in line, understanding all the processes, having a bank of information they can refer to so that there is some element of self-service for the information recruiters need to support candidates. And then also having, regular checkpoints, because as we all know, things change in immigration, timelines change, right? Like I hope everybody's been updating their onboarding timeframes based on premium processing no longer being 15 calendar days, but 15 business days. That may be impacting how you're estimating start dates for H-1B transfers. Things like that you're having the regular protocol documents updated and then influencing new training so as everybody's on the same page for successful onboarding programs. So it takes a lot of care and it takes a lot of maintenance is kind of the summary there. So with that, should Immigration Counsel be involved? When should they be involved? What kind of training? I think definitely rely on your Immigration Counsel to provide you with the trainings your organization needs. So if that's once a year manager trainings, if that's quarterly check-ins with recruiting, depending on what kind of program you're running, what resources are all involved at the onboarding process, that will dictate the tailor-made training that you need. So definitely reach out to your counsel. All counsels do these types of trainings with best practices for onboarding, the ABCs of immigration for managers to understand what classifications, and obviously all the training should be tailored to your program. So if your program only sponsors H-1Bs, you don't sponsor Ls, then obviously the training should only be including H-1B training and what's all involved, timelines associated. If your program has H's, L's, the alphabet soup, then obviously make sure that Counsel includes just high level what's involved, the timing of securing the visa classifications for work authorization, because the manager just cares about when they onboard, and then, of course, cost. But you don't always need immigration counsel within the onboarding process itself to complete the immigration assessments. So I have many clients that have very strong immigration leads, have been in the field for many years, have performed very sophisticated roles within Department of State, and then have gone in-house or have worked at law firms for many years and then go in-house and are very capable of completing initial screenings to understand within their organization the start date and timelines for national candidates. I would say that the clients that are successfully performing internal immigration assessments have foreign national populations of like 300 foreign national sponsored employees or less, that they have, maybe one and a backup persons on staff to complete those immigration assessments. Larger programs most often will have a whole dedicated internal team to complete immigration assessments or heavily rely on outside counsel for immigration assessments. And, depending on the size of the program, they even have a whole team within their law firm that they use to complete immigration assessments. Immigration assessments at a high volume when there are, more than 1,000 foreign nationals are really tough programs to run because the volume can be so high and the turnaround time expectations, generally are within, one business day because things move fast, as we know, with the onboarding, especially if a manager wants to move forward with a hire, they want to know immediately that they can move forward, set the start date. So the best immigration assessment programs that are run by external law firms will be leveraging technology. So I know I've run immigration assessment programs in my past life, and it was all done through email, and then sort of a manual process of uploading the email that completed the assessment into the system for record keeping. It was madness because of all the different billing requirements. So if you're running it through email, it's really manual. It's a lot of time, and it can be really messy. Now I'm leveraging an assessment tool, and it's seamless in that the assessment is entered directly through our portal and that it has all these mandatory fields. So when recruiters are engaging with the tool in our portal, they have to complete the fields, which was a point of issue and contention with other programs that I ran that, we'd get a handoff from a recruiter, but they wouldn't complete all the information. And so there was a ton of wasted time and wasted resources going back and forth to collect all the information just needed to complete the assessment. So now with an assessment tool which has mandatory fields, it requires the recruiter or the talent acquisition team to provide all the information required to complete a full assessment for immigration sponsorship viability. It also then records all that information for very easy reporting. So it's really improved efficiency for immigration assessments because I'm able to report how many of those assessments convert into hires, and that any other data that the company wants to collect, whether that's which recruiters are moving forward with sponsorship candidates the most, which departments sponsor the most, from assessment to onboarded foreign national sponsored employee, things like that, like whatever you want to measure, it's all there and it's all automatic. So the efficiencies are there. I think tech is really key for a high volume immigration program. And then, of course, for assessments, and especially given the quick turnaround time, it's really key. So if you're looking for that kind of insight, you need to have that all sort of built within the program, within a tool that you can automatically pull data and insights. In the past, for me, it was very, very manual. So next, we're going to transition into running through a couple scenarios we've received from global mobility teams. So we've anonymized the data so as to not disclose who's asking the questions or disclose who has these challenges. So we'll run through a few scenarios about this topic, about onboarding and the handoff from talent acquisition, recruiting to HR. So hopefully one of these scenarios resonates with your program and you can garner some insights into how we're thinking through the problems for meaningful practical solutions. So Finn, jump on and let's start with scenario 1.
Cool. So first one here, it's a BioPharma company. They have around 800 sponsored foreign national employees in the US, and they use outsourced recruiters to support their talent acquisition team. Despite having a large foreign national employee population, the outsourced recruiting team does not accurately screen foreign national candidates consistently and often is unable to hand off those candidates directly to the talent mobility team for immigration support. And in some instances, the recruiters, tell managers onboarding timeframes of about 2 weeks. So how would you advise this company's talent mobility team to sort of deal with the situation?
Yeah, I've had this challenge come up with a number of clients. And when they're using an external recruiting team, one of the challenges they often voice is there's turnover in the recruiting team. So whether that's, reassignment of recruiters or recruiters leaving, that there's not this sort of institutional knowledge of the company or my client's protocol for the recruiting team to consistently manage, meaning when they're encountering a foreign national candidate, when is the handoff to outside counsel to complete the immigration assessment? Or when are they looping in the internal team for support? How are they completing the immigrant assessment tool to gather the data from the foreign national candidate? So the first step is there needs to be regular engagement with the recruiting team. So identifying an accountable stakeholder from the recruiting team. And again, this is often an outside organization that's managing this for larger companies or could be for larger companies. So finding that accountable lead to commit to engagement and then bringing in outside counsel, assuming outside counsel is supporting the immigration assessments for your organization, bringing them in for regular training. So that would be, the alphabet soup, but also the HR immigration global mobility team needs to be engaged with training with strong protocol documents. And you can really be leveraging your immigration counsel to create, I'll call them cheat sheets. So you're going to have an immigration counsel train on, immigration protocol. You're going to have your internal team train on your internal protocol. And then you're going to want to have the immigration counsel create like a cheat sheet, which combines the organization's protocol of when to set a start date for each classification, maybe even have a chart with different high-level information. So, most immigration counsels will tell you, between 2 to 5 weeks to secure a premium processed H-1B transfer. Well, 2 to 5 weeks is kind of a big time. It's a lot of time. How are you setting your start date? So you should have some sort of internal process that's agreed with immigration counsel that, okay, your range is 2 to 5 weeks, but what's the accountable start date? And putting that on the chart. So H-1B transfer, we set start dates plus, 25 days. And so that is something that the immigration counsel team can be responsible for, and that is how your recruiters will know to set start dates on offer letters, as well as managers understanding like this is the company protocol. We can't move it any sooner. And then, having something else in the chart about fees. So companies that have that hit the manager's budget or the division budget has a really clear understanding of, okay, I'm sponsoring H-1B. It's going to take 25 days and it's X amount. And that X amount, should include the legal fees and all government filing fees. So the manager just sees like, what's the final total? Because that's what they care about. They're not in the business of negotiating what the legal fees are. They just want to know what's hitting their budget. So I think too long didn't read. It's engaging with an accountable stakeholder with recruiting and creating, cheat sheets so that there is a very clear picture for the pieces of what the recruiting team is accountable for.
Cool. And then the next one here, we're looking at an experienced global mobility lead at a health tech company, and they're evaluating some new immigration service providers to help manage their company's growing program. They currently have about 74 national employees, but they anticipate hiring anywhere from 40 to 60 more throughout the rest of the year as the company's going through a pretty rapid growth stage. So this global mobility lead is looking for a provider that can offer a streamlined solution that helps the company's talent acquisition team assess foreign national candidates for U.S. visa eligibility what do you recommend they look for? Like, what's your advice on what they should look for when they're evaluating providers and the immigration case management platforms that they offer? Because I know there's quite a few out there, including our own.
Yeah, that the assessment process is built into their system. So I've worked on a number of different case management systems, and it only works when the assessments work the best when it's like built into the portal or the case management, because then truly the immigration team and the immigration law firm are only entering the data once, and it's always reportable. So when I've worked on in the past immigration assessments that come through email, it is very manual. It's, you definitely you can still get a quality review and a quality assessment, but there's not the immediate reportability and the reliable reportability. And I think when I've worked with clients, that's what they want. They want to be able to take data insights from their immigration assessments through, their immigration sponsorships, through their green card program. They want to see the whole picture. And the thing you want to be looking for is the assessment piece built into the case management, and is it automatic? So in the past, when, again, I've managed this through email, there was a lot of manual updating of what the assessment was and creating like a profile, again, manually for each assessment. But if recruiters or the talent acquisition is directly engaging in the program and then has these required fields, then it will be a more efficient assessment program. And especially with that kind of exponential growth, you're going to want to have those guardrails, those bumpers in place so that there's not wasted energy, wasted resources going back and forth about what information is required and how it's entered into the system, and that it's entered only once. And that when it's in the system, converting that assessment, that candidate to an employee or onboarding employee is automatic. It's very straightforward. So it's one of the things I love about our system here at WR. Final thoughts here. So I think that's all to say the smooth onboarding process really comes down to a high level of engagement, quality training documents, and maintenance of the training and protocol documents. So I think this is a theme here on the Business Immigration Benchmark is, consistent look at your sponsorship policies. I'm going to add a consistent look at your onboarding policies. And maybe that's all one, but that's a really big task to take all the time. So break it down into bite-sized pieces, maybe thinking about quarterly review and maintenance of, your green card policies in Q1, maybe thinking about reviewing your onboarding and onboarding protocol documents in Q2. Stay tuned for what I'll recommend for your homework in Q3 and 4. But that's all to say that if you kind of just break it into small projects, it's a lot easier to digest. Leverage your immigration counsel to help you update those documents, and tune into the Business Immigration Benchmark to find out what other programs are doing and how they're solving some of these challenges to make sure you're in line with the industry and for other creative solutions to approach these types of questions. As always, thanks for tuning in to this week's Business Immigration Benchmark. You can catch us on Spotify or YouTube. Thanks for listening.